Hi, Steve.
They should be good to talk. To test it.
Hello?
You're good.
No, it takes longer than that. Okay. Is everybody here? Get Sally. Sally, you almost ready? Take your time. Thank Gary. Karen, are you sitting for our other hearings? Okay. Good. Okay. Good evening, everybody. Welcome to the July meeting of the Zoning Board of Review. I'm Kate Atwater Butcher, the chairwoman. We have Chris Zingari, who is our special counsel for some of the hearings this evening. Karen Browning, who is our solicitor. She'll be sitting on the remaining hearings. Amanda is acting as our zoning clerk. Okay. And I'll let the rest of the board, and Sally Broussard is our stenographer.
Bob Crow, Robert Gloucester, Susan Bush, Steve Duffy, Mark McGuire.
Thank you. A couple little housekeeping issues here. Due to a little bit of an emergency on the mainland, we're gonna I'm gonna make a motion to move Christopher Goreb, Jay Goreb, excuse me, plat 19 lot 37 to the beginning of the agenda. It's a very, very quick hearing. It's just a renewal of a one-year extension of the zoning decision dated July 20th, 2023 for an application for a special use permit under Article 3, Section 306E, Article 4, Sections 401 and 403 for a secondary dwelling development. All existing structures will be raised. I made a motion, Lonja. I made a motion on that to move it to first, second. All in favor? Great. Okay.
Thank you.
Sure.
This was a secondary dwelling development on 15-acre parcel south of Champion Road over water that we this is about a year ago. After go through coastal, it's still finding its way through coastal, I've gotten to coastal. No change in the neighborhood, no change in the law as it affects this particular decision. So we're asking for you to give us an idea. Thank you.
No change to the dwellings, the proposed dwellings,
No change to that.
anything, status quo. How far out are you on?
I think we're 3 to 4 months still away from it.
Okay, because last time we did this, we extended it beyond.
You gave it, I actually asked for 2 years, and you gave us a 2-year thing.
Right.
We would obviously not object.
I mean, I don't have an issue in issuing an extension for 2 years, just because why it's time and money on the applicant's side. The have them come back every time, just renew it if they're being held up by the state. Okay. Thank you. I'll make a motion to extend the application of Christopher J. Goria, plat 19, lot 37, for a 2-year extension of the zoning decision dated July 20th, 2023 for an application for a special use permit under Article 3, Section 306E, Article 4, Section 401 and 403 for a secondary dwelling development. All existing structures will be raised. Finding of facts that nothing will be changed on the application.
Exactly the same.
Exactly the same. Okay. All in favor? Aye, great.
Thank you.
Welcome. Okay. Okay. That gets to our appeals. Before we get going on our appeals, there's a couple things that I wanted to say about the process. The first is that when the zoning official issues a notice of violation, it's based on an official complaint that has been sent to the town hall. The zoning official is not walking through people's yards looking to issue notice of violation. She can only do it, or he can only do it on complaints that have been received. So we had a lot of correspondence from the community, which was great because you always want to see the community involved. But a lot of it spoke to this being, this situation being singled out because there are containers all over Block Island and blah, 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 blah. Well, the zoning official can only act on complaints that are issued to town hall by the public. Maybe someone's going to issue complaints on all of them, and then we'll be here till in perpetuity for them. But right now, this is the one that's this is what's in front of us. And the other aspect of this is that we as a zoning board, as some of you may know from our recent issues, that was the last appeal that we did, that we can only look at what is in our ordinance. We can't look to the character of the people. We can't look to the situation. It's purely about what is in our ordinance. It's really frustrating at times because there are times when for example, if we got an ugly house in front of us, doesn't matter. I mean, it's purely what, the size of it is and all those other things. It doesn't matter what it looks like. This is that type of situation where it doesn't matter if it's, Mother Teresa in front of us or the devil. We have to look at the facts of the zoning ordinance and how it applies to the situation. So that being said, VVO Real Estate Holding Inc., Plat 6, Lot 106 and 107, Fire number 41, Water Street, and Fire number 89, Weldon's Way, appeal of a notice of violation dated April 29th, 2024, issued by Karen L. Browning, Town Solicitor, regarding zoning ordinance, Article 1, Section 111, General Prohibitions, number 23.
Hi, good evening.
If you'll just give your name to the stenographer.
And you're speaking about process, so if I may, you want to just address 23 and 19 separately, or I think somebody's already.
Often we just, I'm okay with.
Can I interrupt you for a second? Is the green light on?
Is that better?
Yes, thank you.
Excellent.
Are you okay with us hearing them together?
Hearing them together is certainly fine for economy reasons. But when you take the vote, you'll take the vote separately as to each.
Right. Are you
Okay,
guys
and you'll
okay
make,
with
and additionally, you make a separate finding of fact. for
Right.
each.
It's two separate decisions, here
Yes.
together, two separate decisions.
Yes.
Okay.
Thank you for that.
Karen, are you okay with that?
Okay, great. Well, again, thank you. My name's Josh Parks, and I'm going to take both of these in sort of as one, because I think some of the arguments really do go to both of these same violations. We're here on violation of section 111A19 and section 111A23. And as you know, both those violations were issued by Ms. Browning, who's one of Block Island's town solicitors. And I know you've received what's for, I think, a zoning appeal like this, relatively extensive briefing from both myself and Ms. Browning. So my plan is to just sort of provide you argument, hit the high points. It's nothing you haven't seen already in the briefs. And then frankly, I'm here available if you have questions or points of clarification that you want to hear from me.
Can I just interrupt you for 1 second? Chris, the briefs are already part of the exhibit, or do we have to accept the briefs as an exhibit?
The briefs are already part of the file if they've been submitted to the clerk, so
So
they don't have to
Do
be.
they don't have to be
resubmitted.
marked as exhibits?
No, I would say not. They're part of the file
Okay,
and you've received them.
yes, oh, no, we got it.
Okay. Maybe the applicant would, just to make sure, identify what he's actually filed.
If you have exhibits as part of the brief, correct?
Yes, yes, yeah, no, thank you for that. I'd like to confirm that we have both the brief and sort of presentation that we sent under cover of a July 3rd, 2024 letter in the record, as well as the brief that we submitted just last week. I believe that would have been under a July 17th date.
So that would be the original brief plus the reply memorandum,
Okay.
correct?
Right, just looking. Okay. There's a lot of these things. I'm sorry, people.
Try not to bury you in too much paper.
Right. Right. So this, it's called the dates is what I'm finding. This is the one with all the,
That I believe might be
this
the
is
town.
ours. This is what I'm talking about. This is the date. I'm just looking at trying to find the date. This is the July 18th is what, this is the last. This one. Has Mike's,
It attaches Mike's affidavit.
David, yeah,
Correct.
okay,
Right.
okay. So do you want to mark that?
So these are in the record?
Yeah,
Okay, so if we can call
Yes.
the presentation that went under that July 3rd letter as Exhibit 1, and then I guess we can call the brief that came under the July 17 letter with Mike's affidavit as Exhibit 2, if that makes
okay,
sense.
just to have it.
Great.
It's easier for us to reference them sometimes in decisions too.
Great.
Thank you.
Great, thanks.
Sure.
So now that we have the housekeeping out of the way, again, I'll sort of hit the high points on the arguments here. And for the very first point, and applies to both of the notice of violations issued, is that the notices as issued were done outside of the authority. The state enabling legislation, RIGL 452454, provides for a town to designate a zoning officer or their designee, who's the person who's supposed to be enforcing the zoning ordinance. And there are certain requirements that certain sort of minimum professional standards that the officer is supposed to meet. The zoning officer is allowed to designate somebody else to issue violations, but that's a designation that needs to come from the zoning officer itself. And at least as of this date, we've not seen anything that designated the solicitor as the zoning officer's designee to issue the notice of violations in this case. And it tracks, it makes sense that the solicitor shouldn't be the one issuing violations because it contravenes the intent of the zoning ordinance. If you go to section 707 of your zoning ordinance, for example, it provides the process and frankly gives the solicitor an express task regarding notices of violation, and that's to enforce the NOVs in Superior Court. So to have the solicitor issue violations in the first instance, I think is above and beyond what the state enabling legislation permits, and frankly goes against what is contemplated by the zoning ordinance itself. So I think for that reason alone, the notices violation should be dismissed. Second argument is we were here on two very specific violations. Section 111A19, and 111A23. Now, you can't get to number the enumerated 1 through 28 things you cannot do until you read section 111 sub A, which prohibits use of a premises that is injurious, obnoxious, offensive, dangerous, or a nuisance. And I don't think there's a good faith basis to complain in the case of the notice of violation of section 19 and that's the moped storage one, that these mopeds, which have been stored in essentially this exact same location for nearly 40 years, they're maintained, they're not junked, they're part of Mr. Finnemore's fleet that ultimately gets sold every year. Sometimes they're brand new ones that haven't come in to the rental fleet yet. I don't think there's any good faith basis to assert that those vehicles qualify as a nuisance under section 111 sub A. And that same argument also flows for for number 23, and that's the tents and containers prohibition. And that's the same argument that goes for the violation number 23, which is the tents and containers violation. As everybody here knows, the harbor side suffered a fire last year, and it had to be demolished as the building burned and was no longer safe. And the site had to be cleared, and Mr. Finnemore had to undertake, a pretty significant job to clear the debris. He ended up putting gravel down, sort of making the lot a sort of safe place to be. As everybody knows, it's front and center right when you get there downtown. I think given the fire, these structures are necessary to prevent the property from becoming obnoxious, injurious, offensive, dangerous, or a nuisance. These are the things that he needs to safely operate his business, keep control of his property, and prevent it from falling into disarray until such time as he can get permission from this board to rebuild the harbor side. Continuing along with that notice of violation regarding the tents and containers, and I'll break it out into both tents first, and then we'll talk about the containers, because tents are only prohibited per the plain language of the ordinance for human habitation. Commercial use, which is what Mr. Finnemore and VVO is doing here, is allowed under the ordinance. And this tracks with sort of these basic precepts of statutory construction, which is if there's specific language in a statute, and the statute's listing and enumerating all of these very specific things that you are not allowed to do, well, then presumably, if it's not contained in that list, it's allowed. And I'd submit that the town knows that commercial use is allowed, because after the NOV was issued and this argument was first raised, the discussion's been had at both the town council and the planning board levels, June 20 for the town council and July 10th, June 20 for the planning board and July 10th for the council, or if I'm mixing those dates up, regarding setting forth an ordinance to prohibit exactly what is going on now. Because I think the town knows that under the ordinance as it is currently written, this commercial use is allowed. And I hear you, Madam Chair, regarding what happens elsewhere on the island. But I do think in this case, it's worth noting that myriad businesses all over this island use those pop-up, and most cases are actually blue tents. And that's in large part because it's simply allowed. Which brings us to the containers. And once again, I hear you regarding, we're here to talk about what was complained about in this instance. But, and there's always a but, to apply the ordinance so, mechanically in this instance, really just ignores the practical realities of what takes place on the island. The town has containers on its property. The Historical Society has a container on its property. I mean, these things are absolutely all over town. And to enforce this ordinance selectively against Mr. Finnemore, while I understand an equal protection argument isn't really what's before this board, the board is in a position to, stop that argument from being brought in a forum down the road. And that makes sense. Again, the Harborside burned down through the fault of nobody really. And this is something of an in extremis situation. Mr. Finnemore does not want containers on the Harborside property. He'd rather have a hotel there that generates a lot more income than some shipping containers that are used to store exactly the same things that were stored under the Harborside that's no longer available to him. Bikes for his bike rental business, some material for the Harborside itself, and then a container that's in use by the neighboring Oddfellows Cafe. Which brings me to one more point regarding the record. I received yesterday a bunch of emails that were sent into the town, sort of specific to the Oddfellows Cafe and its use of one of those 3 containers. And I'd like those to be included in the record. If those, I had 5 emails.
Yeah, right here.
I received 5.
Yeah.
Great. Yeah, I received 5 emails. I don't know if you have a different number.
Seeing if there's anyone that I can see. I have 7.
I'd ask that all 7 be included, and I'll make sure I've in fact seen them all before I finish. So I guess we can call those Exhibit 3, if that tracks, just the whole packet of emails.
Exhibit 3 is 7 letters from in support of the containers.
Great. And before I move on to the second violation, the last sort of piece is there is a provision in the zoning ordinance, section 112, to allow basically a temporary permit in a situation such as this. And I think the natural question for the zoning board is, okay, well, why didn't you go in under 112 and where's your temporary permit? What are we even doing here? We tried. We went to the town council on May 22nd with a plan essentially to put up some screening, some Ivy type screening to, make it more attractive than what it was, because we had heard that there were complaints about the way the property looked. And that meeting, frankly, did not go well. Heard a lot from the town council about other ideas, which admittedly are involved doing something that they contend violates their own ordinance regarding more tents. Since that time, Mr. Finnemore simply changed out all the colors of the tents. They used to be blue and red. Now they're all blue. And, sort of kept the place clean and organized, and, it's proceeded on that basis. So regarding that section 112 temporary permit, we tried and frankly didn't get a great reception from the town council. So once again, we're here really appealing to your sort of equitable authority. This board has the authority to affirm, deny, or modify these notices of violation. So, we contend, given the kind of unique situation that's going on at the Harborside, it would be inequitable to affirm the NOV as it stands now. So moving to the notice of violation for section 111A19, which is the moped storage. This one's really simple. Per the very plain language of the ordinance, it prohibits moped rental. The mopeds that are being stored in that location next to Oddfellows are not part of the rental fleet. And this is really easy to tell. The town has a whole system for identifying mopeds that are in the moped rental fleet. There are stickers and decals, and they all have to be registered with the police department. I've been pretty intimately involved in how that all came to be. And these mopeds are not those. They're just simply not being used for rental. You have an affidavit that's part of Exhibit 2 to that effect in your file. And what's a little more concerning is the Superior Court has already weighed on this. Island Moped was in Superior Court a couple of years ago on its operations at lot 106 and part of lot 107, which is the lot that the Harborside stood on. And there was an order from the Superior Court, again, it's in your file, which said that Island Moped is allowed to operate in the same area it has historically operated. Nothing has changed regarding Island Moped's operations or the area in which it's operated. The moped storage on that corner of the lot has been going on for nearly 40 years. Nothing has changed since. And there are photos in our Exhibit 1 that show you that at least some of the history of how long those mopeds have been sitting there for. Sure. Yes. The Judge Tapcarter. So yes, I mean, what will, well, I think if the board upholds the notice of violation as regarding the mopeds, now I think the town is basically in contempt of a court order. And so we would probably move forward on that basis. But I think that, hopefully we don't get there because I don't think the notice of violation sort of stands in any event, even setting aside the court order, right? These aren't rental mopeds there. So it simply doesn't fall into 111A19. So I'd like to not reach that sort of second point, if you will. Just very briefly, there was an argument raised in the submission from the town regarding signage as regarding those mopeds. And I want to be very clear, that's not before this board. VVO and Mr. Finnemore were violated under 111A19, which is the rental of mopeds. This whole argument regarding section 504 of the zoning ordinance as relating to signs, no violation was ever issued on that basis. And to bring it up as we go through the appellate process isn't the right way to go about it. And it's simply not an argument that's before this board. So for all those reasons, I think both of the notices of violation should be quashed. Thank you.
Any questions?
Yes, I like. There's a, can't find exactly where it is, but it's clause for emergency.
That's the 112, right?
So are you saying that you went to the town council and said, we need storage containers because we have no place to put this and you would have been lying?
Excuse me. We went to the town council to talk about that issue and really the whole visual issue there. And it turned into a back and forth of, well, we don't like your proposal. Maybe here are all these other things, but we're not saying go do it. But we're not saying go do it. That's sort of where that came. I mean, there was a suggestion to put the containers underneath a wedding tent. And I'm going from memory. It's the meeting's on YouTube. It was May 22nd. So it sort of devolved into that.
The council minutes that night say Keith Stover stated that the council is flexible and is willing to allow VVO to work with Karen Browning, Mary Ann Crawford, and the Land Use Zoning Department to come up with an amicable solution. That's from the council minutes from that 22nd.
Okay.
So your party did not like the solutions that or the ideas that came up.
We offered ideas, were shot down, and then sort of a bunch of spitballing, be colloquial about it happened, and then nothing ever came of it from there. We did bring a plan.
What is the purpose of the portable tents?
So the portable tents hold bikes up on lot 107, and there's some involved with the moped rental operation back on lot 106, where Island Moped traditionally operates out of.
So what's the purpose of those tents?
Cover.
Cover from the elements?
Yeah, yeah. The
Storage?
elements,
Cover for storage?
the bikes are stored under them, yes. All sort of on the harbor side lot. Mopeds are not stored under them on the harbor side lot. Frankly, standing here right now, I can't tell you if mopeds are stored under tents on lot 106 or not overnight.
All right, thank you.
Thanks. Now you're testing me. Do you know if that was in the first or the second? Bear with me 1 minute, please. Yes.
So. It's ambiguous. Only when it's unambiguous. We have to read it in plain ordinary meaning. So. Tents aren't really cited in ordinance, correct?
Right. There's a prohibition against using tents for human habitation. No, nothing in the ordinance prohibiting tents for commercial use, which is how they're being used.
Town council said there's no tents.
I frankly, I don't want to mix my meetings up. There was the meeting where we came to the town council to try and discuss what's essentially this section 112 special permit. That was a different meeting that preceded the meeting where the town council had a colloquy where they acknowledged that they had no ordinance that prohibited the commercial use of tents. And in the first brief, I think we have a little screenshot of that. Correct.
So this ordinance. Why did I ask you?
I think you and I are on the same page on that. I think that tends to suggest that the ordinance as it stands that we were violated under does not cover the activity for which we were violated.
Did that? Did they go retroactive? Or would they be considered grandfathered?
I would think we'd be a pre-existing non-conforming use. But again, I think that might be a topic for another day, which hopefully we don't get to.
So disputing. Says similar temporary and or mobile facilities for any commercial or industrial activity, can't be a tent.
Correct. I think it's, it's talking about trailers, containers, I think those are, yep.
I think when I read the ordinance, it seems like the intent of the ordinance, that you don't have to, someone comes up with a small construction trailer, but opens it up. And it's kind of, that's kind of the intent.
Well, wait a minute. Like a lot of times these tents, they come up and down. These aren't coming up and down. They're zipped up like a pack. They're only akin to what a pack and play looks like when it's packed up. But they're not, when you think of it, a tent goes up, it comes down, a tent goes up, it comes down. These are not coming up, these are staying. And I also, sorry to interrupt, but I just was, because that is one thing that keeps coming up to me is you refer to it as a canopy. It's referred to as a canopy tent in some of the brief, and then
Yep.
it's, a canopy is different than a tent, doesn't have top sides.
Okay, so to be perfectly frank, in my mind, I'm not making a distinction. You know,
Semantics, but
it's we're talking about these 4-poster pop-ups.
they're just not pop-ups is what.
Got it.
So, do you know if anyone's been given a violation before the tenants in the foundation?
I-
Using this,
I,
it seems like
I do not know that, and from having tried to figure this out a little bit since this has come to the fore, this is the first that I have been able to uncover.
Mark? Yeah.
I had, just to understand this May 22nd meeting of the town council, you guys brought a proposal. The minutes say that they asked you to work with the town's representatives to come up with an acceptable, and then it was just dropped from there. So the town council never voted on a temporary permit.
Correct.
Is there a process for applying for a temporary permit other than putting it on the agenda for the town council? I mean, is there a record of an application for a temporary permit? I just don't know that.
The permit would be issued by the town council.
But how about the application for the permit? Or is it just getting on the town council agenda and saying, I would like a temporary permit and then voting? Is that the application process? Or is there, like, when we do a building, you have an application, you write it down and you submit it to us and then we review it. Is there something similar for a temporary permit?
I don't know for sure if there's an application process. I would expect there would be.
Sorry.
Sure. Yeah.
Okay, another question is, can we send them back to town council? To
N-
take care of it,
No,
to clean it up or no?
no, you have to make a decision.
I mean, I know we have to make a decision, but could that, is part of the decision be, okay? This is.
I would
you
say
know,
no.
Yeah, okay.
You could make a suggestion, but
Too late?
you don't have you don't have the authority to instruct them to do that. You could make a suggestion.
Okay.
You could say, I'd like you to do it. Other than that, no.
I mean,
the fact about this whole permitting, can that weigh in our decision? Or is that
I don't think it should. Because it's whatever they did before the town council and whatever the town council decided or didn't decide. I don't see it as relevant to your determination this evening as to whether or not this applicant, this appellant has violated the ordinance and whether or not the notice of violation should be upheld, modified in some way, or overturned. So the fact that they went to town council or not, to me, really shouldn't factor into your decision.
okay, so I have a question about the mopeds on Water Street on the corner.
Yep.
Advertising mopeds, I'm gonna call them, because that's what they're doing. They're not even, are they not only part of the fleet, they don't even rent what they're showing up there. Like, so is that a violation in its own right? That you're advertising, you know what I mean? Like, that yellow moped with the little side things? Pretty sure I haven't had to drive around one of those things on the road.
Right.
So, like, if you look at the picture of what they have out there, it's, I guess my question is that, I know that I just want more clarification, I guess, on this.
Sure. So
Here, maybe cover that.
So to the extent we're talking about advertising, again, that's not before this board. You know, that was raised in briefs after the notice of violation was issued. The notice of violation was issued solely about rental mopeds. And the facts are that these mopeds are not being rented. So
They're just storage.
they're there. They simply don't fall under the section of the ordinance for which we were violated. You know, that being said, this has been going on for longer than the zoning ordinance has come into place. So as testified to in Mr. Fenimore's affidavit, so that would be a pre-existing non-conforming use. That would be a pre-existing non-conforming use. But I think more importantly, the Superior Court already opined on all of Island Moped's operations. Island Moped holds a license to operate on lot 106 and portions of lot 107. And the Superior Court has already basically sort of set the grounds as to what was permissible and what wasn't. And these operations have not changed at all since the court found that they were okay. So the court heard a lot of, there were a lot of hearings about this. Again, I don't, recall the specifics of who testified to what from a couple of years ago, but this was a contested case that went to hearing before the Superior Court.
If what you're saying is true, then isn't the town in contempt of court? And isn't there an avenue for you to go and get resolve on that?
This is what I was, this is what I was talking about with Mr. Filippi earlier, and I think yes, but I think hopefully, if only it were always that quick. I think hopefully we're in a position where that's not a road we need to go down. Good question. In this case, no. This isn't really an administrative procedure. To my mind, and I'm sure somebody will disagree. Right. I think where we are now is a notice of violation was issued. Rightly or wrongly, we contend wrongly, and the process is we have to appeal that to you. So we're here. I think because of sort of the unique flavor of this particular property, there is, most cases don't have a Superior Court order that bears upon them. So that sort of is another road to go down. But just given what we're doing here tonight, there was a notice of violation issued. We appeal to you pursuant to your zoning ordinance. So you're stuck with me.
Well, there's some ambiguity in the order. I mean, it says they can operate in the same area applicable to any laws, ordinance, and regulations. So,
That's not, that's.
right, I mean, right, but it's not perfectly as clear as they're making it out to be, to me, anyway.
Island Moped operates on 106.
It's whichever one's the back one, right? It's the 106, yes. And then there was a portion of lot 107 as well. And that was all litigated and permitted. And if you look at the license, that's what it says.
106 and 107.
Yes.
Because the court order doesn't mention where it's operating on 106 or 107.
Sure. The order says what it says. I agree. It doesn't specify the lots, but the court order said that how it was operating was permissible, and it's operating in the exact same manner in the exact same location as it was operating when the court rendered its order. Well,
It's got
it's
storage facility.
It doesn't have a
instead of
building that,
building.
yeah. I can't really speak to what other municipalities are doing. I think what the ordinary process is that the zoning officer would designate somebody, in the zoning office. I understand in a small town, there's, you're shorthanded, right? It's a small community. But I do think it would be somebody in the, zoning or building office. I also think it would be a designation that, we would know about, right? There'd be a written designation, and that's just not something that I've seen. I can't cite any offhand.
Your ordinance was amended in 2003, and the section is 2003-06. And the first line, A, is designation. The zoning official shall be designated by the town manager. to assist in administration enforcement of this ordinance. You have that. That's your zoning official. Here's the second part. They may be provided with the assistance of such other persons as the town manager may direct. So the town manager may direct a designee, and that's when you get to paragraph 4 of that ordinance, where it talks about the duties of the zoning official or their designee. I would submit to you the designee would be appointed by the town manager or made aware as their designee by the town manager. I think there was, Josh mentioned something. He mentioned that it would be designated by the building official. I would suggest the ordinance indicates it's by the town manager. So if the town manager designated someone, that person could do it. Is that a little unusual? It's a little unusual, but it's a valid ordinance in your town. It was passed by your town council. So that's what you're dealing with. That's what you should go by.
Any other questions?
Same owners of 106 and 107, correct?
Believe so. Again, I'm not 1,000% certain, but I think that's the case.
Questions?
Nope.
Oh, good. Mark, you-
One more time, why should we do that?
In a short answer.
This is the selective enforcement piece, and this is all the selective enforcement piece. Selective enforcement. And this also goes to the unique situation that we find with the harbor side, which is it burned down through no fault of its owner. And this is a temporary situation that frankly, as soon as can be done, something else will be built there because it's makes a lot more economic sense to have a hotel than to have a gravel lot with some shipping containers on it. So that's the other thing I would be remiss if I did not remind the board of, which is this is very temporary, as temporary as we can possibly make it.
Anybody? Okay, that's great. Well, I mean, wait, would you want to wait for Karen? Why don't we let Karen?
Okay, great. Thank you.
I think, thank you.
Good evening, Attorney Karen Browning on behalf of the town of New Shoreham. Madam Chair, I'd ask that the town's memorandum and associated exhibits be made part of the record. I believe that's Exhibit 3.
You want them all together, this one?
Together's fine. Hi, similar to my brother, I'm going to run over the highlights of the papers that have been filed. The matter has been briefed. So to the extent I do repeat, I apologize. I'm also going to try to address some of the questions that were raised. First, as to solicitor's authority, the special counsel is correct. The zoning ordinance was amended in 2023 to include the zoning official or their designee can issue zoning violations. My office was contacted by the town manager and designated to issue both NOVs. The idea that a solicitor can issue is consistent with both Rhode Island General Law 4524-54 and 4524-62, which says that the local zoning ordinance designates who can issue and also says that any similar action brought in the Supreme Court, the Superior Court, or any municipal court, including municipal housing court, can also be brought by the town solicitor. It would be absurd to think that I, as your solicitor, can bring a zoning enforcement action in every other court in this land, but not to you. especially when your zoning ordinance allows for a designee, and I have been properly designated by your town manager. As to the NOVs that were issued, the first one issued April 29th, 2024, by the affidavit of Mike Shea, Director of Public Works for the town of New Shoreham. That NOV alleges the shipping containers and tents for commercial storage at the property are a zoning violation. As to the Section 112 permit, what happened was the property owner filed a request with the town council. There was a hearing on May 22nd, 2024. At the hearing, the council simply asked for the parties to work together to agree to some screening. The property owner's original request actually said that that is something, screening should be something that's mutually agreed to among the parties. At the end of that meeting, the first warden instructed the applicant's attorney to work cooperatively. I will state for the record, my office did contact the property owner's attorney to start that conversation. Some items were offered, and there was never a response. There was never a request to come back to the council with any sort of a screening plan. Now, that Section 112 permit is not before you tonight. Those permits can only be given by the council. But the fact that they were there to request a 112 permit, Section 112 says those permits are only issued for uses that otherwise would not be allowed. I'm not quoting there, but that's the general gist of it. So just, in my opinion, just by asking for that permit, they are saying that certainly the shipping containers are not allowed. And based on the discussion and the idea, I would expect that if the council were to issue that permit, they would include the tents as well. But that's the town's position. As to the shipping containers, the property owner really hasn't raised a real argument as to the shipping containers being allowed. They are at the property. They're being used for temporary, commercial activity or storage. That's admitted. They are listed as prohibited in Section 111, General Prohibitions. This is exactly what the ordinance says you cannot do. So the town asserts that as to the shipping containers, the board must uphold the first NOV as it's been issued. Now, as to the tents, the property owner raises the issue that Section 11 does not use the word tent. The property owner in his affidavit admits that both the shipping containers and the tents being used for the same thing: temporary commercial storage. Their affidavit at paragraphs 10 and 11 says both the tents and the shipping containers are being used for temporary storage. Section 111.23 intends to restrict temporary commercial storage or activity except by contractors on a permitted construction site, which this is not. There's no building permit. There is no construction. Section 111 is not meant to be an inclusive list. If you look at Section 111A at the top, where it talks about things, the nuisance idea, that this list is, this list is intended to prohibit nuisances. Section 111A, I'm sorry, because it says including but not limited to. So there is a list of things, specific things, but at the top it says including but not limited to. So the list is not meant to be all inclusive. Number 23, which is at issue tonight, also says and similar temporary or mobile facilities. So while the word tent isn't there, the ordinance wasn't trying to list everything. Language was put in there to catch other similar things, which could be used for temporary commercial storage, like four-sided canopy tents. The property has both shipping containers and tents. They're being used for the same thing. The property owner should not be able to place both at the property, use both for the same thing, and then only have one prohibited, the containers. That would be kind of absurd. To agree with the property owner would allow every commercial and industrial activity in the town of New Shoreham to use temporary tents for commercial and industrial activity or storage. And that's not the intent here. For this reason, the first NOV should be upheld as issued as to both shipping containers and tents. I will point out, this board has deference when interpreting its own ordinance. It is the law in Rhode Island that a reasonable interpretation of an ordinance must give effect to every word wherever possible. Appellants have pointed out to a couple of town meetings where they're talking about 10 ordinances. First of all, this board is in charge of interpreting the ordinance, not the town council, not the planning board. And as we know, sometimes there can be a difference of opinion among the boards. The zoning board is in charge of interpreting the zoning ordinance. It is true that there is no ordinance for tents. Any ordinance that is to be enacted would allow tents, would regulate tents. This did not prohibit them. Section 111 prohibits temporary structures in similar facilities and also tents for human habitation. So it is under that section 111 that tents are prohibited in these ways.
That's-
Hmm.
This is the. That's all.
Human habitation is, right, human habitation is only brought up because that's the other spot where the word tent is mentioned. That is not correct. That is not the provision that this NOV was issued under. Yes. I don't know about the whole zoning ordinance, but I'll go with you on that. That's probably true. Tents for human habitation are absolutely prohibited under section 111 as a general prohibition. Correct. But if you look at section 111A, at the end, it says, including but not limited to. So that list where you find tents for human habitation, that list was not meant to be all inclusive. There should be other things that are similar to that, that you could interpret under that 111A, that could also be prohibited if you should so find. We are arguing that in addition to that, the provision 23 at issue here also has or similar facilities. Taking both of those together gives some breadth to what you have to determine. You're not just looking for the word tent. You're looking to make an interpretation as to whether or not the tents in this case are a violation of subsection 23.
With your interpretation, why is a tent a similar template?
So if you can, if you're using it for storage, commercial activity, and it is providing a similar function as a shipping container. What does a shipping container provide? It provides coverage from the sun. It can provide shelter from the sides. It's a way to put commercial storage in a place that protects it from the elements. And that way, a tent and a shipping container are serving the same purpose. If you want to get into the building code, it can be yes. Rhode Island general law also mandates that it should be at a certain size, inspected for fire protection. But yes, the state building code does include tents as a structure.
Would,
The state building
state-
code, and that's not an issue here.
would that be, these tents are, I don't know what the size of them are, they're 10 by 10 or whatever they're, 10, yeah, whatever they're, are they, would they be considered a structure, like, would that be considered a structure? Do you know that?
I don't know that. I would have to research that. I know,
To the, for the fire, what you just.
correct, the state law that I referenced has a size amount. It is bigger than, one of the canopy tents out there. Much bigger than just that one tent. If you string them together, does that change things? I don't.
You'd see where in the code, this fire code, state fire code, there'd be, wedding tents, for example, that never come down on these.
Well, one at a time, guys.
Would be an issue.
Seems like that's-
I was accused.
That's why they did it.
Okay.
Didn't say.
Definition of structure.
Mhm.
They meant fence. They put fence in the west, right? Pretty unambiguous, case of states.
Mhm.
So how are we supposed to get there by 10 when it's not there? It's, anywhere it is.
Mhm.
It's not for human.
Well, where tent is mentioned, yes.
Doesn't say permanent.
Yeah, great question. So, yeah, I understand. And all I can say to that is, it is a general premise of zoning and land use law that zoning ordinances are always trying to play catch up. The minute you enact a zoning ordinance, there's always some new technology, some new use, some new thing that's coming out that hasn't been contemplated. So I don't know why the word tent wasn't put in there. But I do know that the council or the drafters included the and similar to protect this very situation from people deciding, well, I won't use a shipping container, but I'll use something else. The question becomes, does the tent in this case fit that section 2023? I don't know the answer to that.
Well, I can tell you it's in the 25 years, 40 years, my whole life. I've been doing this. I don't remember ever having a notice of do you remember a notice of violation on a tent?
And I will say,
Structures, the conversation of what's a structure, what defines a structure, all those things, but not I don't remember a tent. I could have not been around for a meeting or whatever, but.
And then the town council, who initiated this, is on the record saying, we don't have a limit. So that's kind of this is the question I have.
yeah, absolutely. But again, if there is an incentive or a charge to adopt an ordinance for tents, that ordinance wouldn't be to prohibit them. It would be to allow them and regulate them. So that hasn't happened yet. So that means, no, we know that the ordinance does not, there's no tent ordinance. Correct.
Well, we're not.
Well, hold on.
Hey, hold on a second. Hold on a second. We're not talking what's going to happen in the future. We're talking about what's happening right now.
But procedurally, I just want to make a distinction. If an ordinance is going to be enacted, and you're right, we don't know what it's going to say. Generally speaking, if you're enacting an ordinance, it's to regulate something. If you're just going to prohibit it, you're going to just add it to something. You're going to make an amendment. You're not going to go through the trouble of going through an ordinance. But you're right, we don't know what that's going to say. And there is no 10 ordinance as of right now. But that doesn't mean it's prohibited. We don't have a tent ordinance, but tents for human habitation are prohibited. We don't have a tent ordinance, but the town would assert that it is a similar facility storing commercial goods on a temporary basis. That's my argument.
I guess I would make the point, and to get to the distinction on a tent, if we had one of those large semicircular tents that you could drive a pickup truck, but drive a 18-wheeler into, I don't think it would be
You
any,
mean like the one at the fire barn?
I don't think there'd be any ambiguity about whether that was a temporary storage structure, even though it's a tent. But this situation might be a little more ambiguous. But I also, one of the questions I want to know is what leeway. We don't have much leeway. I mean, we are, in other words, we can't, in our decision, say something like, yeah, they're not tents for 2 years, or they're allowed for 2 years or so. Until construction starts on the hotel. We don't have the authority to say that,
It's
right? That's the
it's
town
hold
council.
or Overturn, right?
I think the issue that you want to determine, and then you will determine this, is whether or not under subsection 23 of, or paragraph 23 of section 11, the general prohibitions, is a tent, does it meet the definition for you? Is it a temporary and/or mobile facility that's being used for commercial activities for storage?
So
For
quick
storage.
question for you, Chris.
Yeah.
When the appellant says the petitioner in Exhibit A stated petitioner will be submitting an application pursuant to section 112 to allow for temporary storage via canopy tents and trailers due to the fire.
What's your question?
They're defined.
They're defining the tent for storage purposes, correct?
Oh, you mean the applicant in their temporary?
In their exhibit, they said that they would be applying under section 112 to allow for temporary storage via the tents as well as trailers due to
Because
the
it's
fire.
prohibited.
Yes.
Yeah.
I think the argument that counsel for the town is making, that Ms. Browning is making, is that that's an admission. I'll leave that to you as to whether that's an admission that they're violating the ordinance. Right? That's her argument,
Well, that's, the appellant put that in their exhibit A. What I just
that they're
read.
using it for storage.
Yes.
Okay.
But they've admitted here that they've been talking about they're using it for storage. I mean, that's not, no one's denying.
Storage.
But it's still, I think it still gets back to the question. The issue for you to decide is whether or not that tent, and they say they're using it for storage,
For temporary. storage.
is a mobile facility for temporary storage. Does it meet that requirement? A similar temporary or mobile facility?
And then
That's the issue.
And then it continues and says, or industrial activity or storage.
That's right. So is it a temporary mobile facility for commercial storage? You're gonna, well, you determine that, not me. Okay. Are you comfortable with that? All right.
Thank you.
Any other questions on the first
other questions
NOV
for-
before I move on?
Okay, go ahead.
Okay, as to NOV two, that one was issued on May 14th, 2024. At the time, that NOV was issued, it was believed that the mopeds being stored along the Water Street frontage were being rented. After the NOV was issued, the property owner responded and said, no, they are just for display. The town asserted in its brief in response that, okay, well, if it's for display, then you've got two things going on here. One, it's an intent to draw additional business to the property. That would be advertising. You have a very broad sign ordinance, which we believe it would fall under. And or if you're not, then if it's not signage, then and those mopeds are not in serviceable condition, they are violating what I would call colloquially, however I'm saying that word, as a junk storage of unserviceable vehicles, also a violation. Then the applicant appellant in their reply brief indicated that no, they are actually selling mopeds and they're selling upwards of 30 to 40 a year. This is a problem. Vehicle sales like this is not allowed in the OHC zone where the property is. They're only allowed in the SC service commercial zone by a special use permit. Now, the fact that the NOV was issued for a possible rental violation, and that has now, through evidence gained during this process, we found out that it's a sales issue. Does that cause a problem? It does not. The law protects this very situation. Your standard of review is that you stand in the shoes of the official who issued the NOV. That means that you can modify it and, in the words of the law, do what ought to be done. We would ask that you amend the NOV to find that vehicle sales is a prohibited use in the OHC zone and is therefore prohibited and must stop. The fact that the property owner may have been doing this for a long time is meaningless before this board. Zoning boards have no authority to determine the legality of non-conforming uses. The court order. The court did not rule on these issues at all. The court case was as a result of a licensing dispute about the area of operations. It had to do with area, not zoning. The May 3rd, 2022 order is also specific to rentals. The papers in that case, including an affidavit from Mr. Finnemore, and the order itself talks about the rental business, not the sales business. There is no indication that sales were happening or addressed by the court in that case. The order also expressly permits them to operate in the same area that they operated its moped rental business during 2021, subject to any laws, ordinances, and/or regulations that may be applicable. What does that mean? The court said, well, here's my order, and by the way, you also can't go ahead and violate the ordinance in any other way. You're still subject to the zoning ordinance. So it is the town's position that you do have the ability, if you find a zoning ordinance violation, to issue that violation to the property owner. And for that reason, the town requests that NOV2 be amended and that you do what ought to be done if you should find that there has been a violation of the ordinance due to the fact that there are mopeds on the Water Street frontage that are being displayed and sold at a rate of 30 to 40 a year, which would constitute vehicle sales. Vehicle sales. Any questions for me?
Any further questions for Karen?
It's kind of a two-second
Sure.
reply. I won't tread over all the ground. I'll be very brief. Just on this point of tents, my client reminded me that the tents have a lot of uses. One of them is where people get fitted for bike helmets. Staff use them to get out of the sun, sort of just operationally. They're used, in and about the course of renting bicycles and mopeds. It's not just, throw your tools there, button the thing up and walk away. The other point that I wanted to address is, Sarah, at the end, you had asked a question about leeway. And I do think you have a fair bit of leeway. Your power here as a board, as regarding the NOVs that were actually issued, is to reverse, affirm, in whole or in part, or modify. And so I do think that this board isn't either, necessarily going up or down. You have the ability to fashion appropriate remedies for the notices of violation that were actually issued. This retroactive attempt to turn a violation issued about rental mopeds into something completely different, I think is just a total trammeling of due process rights and not properly before this board. Thank you.
Sure.
If that is the case and there is other activities going on in a new area of the property, possibly where the Harborside building once stood, that would be a violation of court order. So I don't know what to do with that statement. As to the amending of the NOV, the law is clear. You have the power to do it. And the alternative, frankly, would be to agree with my brother, in which case a new NOV will issue immediately for the vehicles.
So we could issue a new.
We could amend.
The town, if you're not inclined to, amend it and do what needs to be done here, the town would still have the ability, tomorrow or next week to issue a new NOV for auto sales, in which case we will be right back here next month to deal with the same issue.
Questions for Chris? Right, these are public hearings. Anybody in the audience have any questions or statements? Anybody else? You're good. Okay, well, then I will make a motion to close the 2 public hearings on the notices of violations and take it under advisement.
Second.
Any discussion? All in favor? Aye. Okay, great, thank you.
So no decision this evening?
We're gonna have to talk about that. It's, I don't think it's like a fly by the seat of my pants kind of decision.
So there's gonna be no discussion from the board, like. if-
We
if we take off, or.
All right, so we typically will discuss the hearings at the end of our meeting. Just for in the interest of all the other applicants that, so they're not here.
Understood. So the board will be discussing what Ms. Brown
Yes,
and I have been arguing
we
about
do.
tonight.
And just so you know, so there are times when we might have a board member that's just like, listen, I need to digest all of this again. Can we have a discussion about it after I've digested it again? Read back through the briefs, whatever. So the discussion may not actually happen and it may happen at a later date, in which case you would be notified. I think.
And the decision wouldn't be until August.
And we don't issue a decision, we want to issue a decision on it until the
Yeah,
August.
No, I totally appreciate that. I just want to make sure the board's still going to be discussing.
Or if you're gonna
this.
sit here, you want to know if she should sit here.
Right, right. If the board's going to be discussing this evening, I'll certainly remain. I
Right,
just
of
didn't know
course.
If you were not, I'd leave, so I just didn't know.
Okay.
Just don't know the process.
All right, hold on 1 second then.
But during that time, you can't
You can't-
participate
you can't.
in that discussion, which you could check us out on YouTube later.
No, it's just 2. It's just,
Aha.
this is the building.
I was intending to leave after this first.
Okay,
one. So, but if we're going to discuss it later, I will stay.
well, I mean, it's 7:20. I just feel like there's people been sitting here a long time. Yeah. I just in fairness to everybody and to speed this along and get, so we'll hopefully get to it at the end of the. Yes, at the end.
Understood.
Okay. The third hearing of the evening is VVO Real Estate Holding Inc. Plat 6, Lot 107, Fire 41 Water Street. It's an application for a variance to reconstruct the Harborside Hotel. They're requesting a continuance. Are we continuous?
My understanding is that was.
That's what I'm saying. You're requesting a continuance.
Yes.
Yeah, okay. Do you know, do you want me, am I scheduling this for the August meeting?
Yeah.
Is that okay? Okay. I'll make a motion to schedule this for the August meeting, which is August 28th. Okay, second. Okay. So we'll schedule it to August 20, yeah,
Thank you.
okay. All in favor? Great, okay, thanks, okay. Okay,
So one of your members, is leaving, so you will not be discussing the application we just argued later.
so
Mark, you're not coming back?
I will come back if necessary.
Well, I think you should be part of the
Yeah.
discussion.
Yeah.
So that's my question. Can I discuss
Do you
it?
want, we'll text, because we have two,
Special counsel and
Yeah.
then, no, but we have,
I'd rather
we
let
have
those
three,
be
each, three or four.
we have one, two, we have,
We have three that have been waiting around.
yeah.
It's not fair to do
I mean, typically, our process, the way that we work on this is we work on our thought process at the end of a meeting so that people aren't having to sit through this whole thing. So, Mark, we can text you when we get, what's your cell phone number?
571
I have
205 395.
Okay, we'll text you when we get to Hart.
We have a few minutes.
Okay. Thanks. Okay. All right, so the fourth hearing of the evening is Peter and Susan Gibbons, plot 8.108, fire number 281, Old New Haven House Road, application for a special use permit under 513D for construction of an accessory dwelling unit for year-round residents. I am, I spoke to abutters who are clients of mine. They're not taking a position on this, so I don't feel like I need to recuse myself. They're not here. They haven't, they've asked the questions. I talked to them about them. They didn't have an issue with it, so, I feel comfortable sitting on it. Is everybody okay with that? Karen?
Yes.
Okay, there's nothing for sale there. It's not, they don't have any houses on it for me to rent. Okay, so, hi,
You want to hear from us?
I want to hear from you. Wait, hold on, wait, oh, Sue, hold on, you're gonna have to get sworn in, sorry. You, can you, Sue, could you sit at this one? And if you're gonna have documents to show us that are in the file, we're gonna mark them as exhibits as we go along, and I'll lead you on that.
Okay. All right, so Susan Gibbons, 281 Amy Dodge Lane. We're requesting a special use permit. Still ahead,
We're gonna swear you in.
my name,
Take your name again for the record.
Susan Gibbons. I do. Okay, now.
You're right.
Okay. We are requesting a special use permit for construction of a 513 year-round rental on our property. We currently have an existing foundation that is in place. It's been in place for just over a year. And we had originally designed a building to go on that foundation as storage. Then we adapted the need for that building, decided to change it over to 513 year-round rental. It was originally meant to be storage and then an accessory unit, but we decided to go to 513. So that's the reason that the foundation was put in place at a size that required us to get a special use permit to change the final construction to 513. So the only reason we're here really for a special use permit is that we have plenty of room on the property. We have the building permit for all of the things. We have the foundation in place. The reason we need a special use permit is we are above the 1,200 square foot maximum without a special permit for a 513 construction. So that seems to be the only reason we're outside or that we need a secondary request to zoning. We do have positive reports in from the Conservation Commission and Planning Board as well.
The actual square footage is 272 additional, more than what's allowed.
Yes.
It triggers that.
Yeah,
special
it
use.
triggered, yeah, that's what triggered the special use permit.
Okay, I am going to show you things that we're gonna mark as
Certainly.
exhibits, so we have to refer to exhibits in our decisions, so your plans, et cetera.
Sure.
I'm just gonna find them from us. Okay, exhibit one. What are these?
What are those?
Yes,
Those are photos of our existing home on the property
and the,
and the existing foundation.
Okay.
Yes.
so,
So the only building, livable building on the property right now, we have 2 storage sheds actually, but, and they're pictured there somewhere. We have a home that's pictured there and the foundation that's currently in place and capped.
okay, applicants exhibit 1 are photographs of the existing conditions, buildings, et cetera, on the property
Yes.
and the foundation. Yeah. Okay.
It's a quiz. That is the site plan and the septic plan that was designed by Ken Cole. The septic system is in place and has been noted, what's the word? It's in conformance? It's in conformance, yes. So there's a 3-bedroom septic in place for the new construction, separate from the septic system for our other home.
Applicants exhibit 2 is a site plan and septic plan by Atlas Engineering dated 10/25/23.
Yes. And that system is complete.
Like show and tell.
Those are the construction plans, blueprints drawn by Peter for the new cottage.
We'll hold it there. Applicants exhibit 3 building plans. Okay.
Okay.
Oh. Freshwater wetlands permit.
Yes, that came in before the septic system. There is a pond on the property. So we had to get a freshwater wetlands permit and work with DEM before that septic system was designed and put in, and that relates to that.
So applicants exhibit 4 is the freshwater wetlands permit. Application 230162.
Yes. Right.
Um. I mean, it's pretty straightforward.
Right, I don't know.
I mean, any questions, Karen? Is there anything that I'm missing?
Yeah, this one's an easy.
It's easy. Yeah.
And the purpose of this is for a year-round rental?
Yes, for year-round rental,
This is,
513.
Because it's a special use permit, and we have steps that we have to follow in decision-making on special use permits, it's not a end of the meeting decision. So I will make a motion to close the public hearing and take it under good advisement. Any discussion? Oh, this is a public hearing. If anybody has anything to say or ask or statements. I'll make, okay, motion made and seconded, all in favor?
Aye.
Great, okay, thank
Okay.
you. Okay. Fifth hearing this evening is the Daniel FJR Trust, Daniel Hart FJR Trust, I want to say that right. Plat 2, lot 19-1, fire number 745 Corneck Road. Application by Devlin Hart for a variance from section 306(6)C and a special use permit under 513D for construction of an accessory dwelling unit for year-round residents. Hi, Devlin.
Hello.
Hi, how are you? I'm gonna do the similar thing for you. You'll go through your file.
Mhm.
Um,
Need me to.
you need to be sworn in.
Devlin Hart. DEVLIN. HART. I do.
Okay. Hi,
Hi.
so tell us what you want to do.
So I'd like to build a 513 on my family's lot, 745 Corn Neck Road. There's an existing structure there which I intend to demolish and install.
Just push it.
I can take care of that. And install a full foundation with a 513 for year-round housing for my family.
Okay, I am going to ask you to mark some. Tell me what I'm looking at here. Looks like to me like building plans, these the building plans?
Yes, those are building plans from Oregon Designs.
So applicants exhibit 1 or it's a site plan or
That's just a general
topography.
topographic.
Yeah. Building plans by Horrigan designers dated 4/25/24. Sure. Is there a bigger site plan then? Oh yeah, here it is. No, I knew it was here somewhere.
That is the site plan from Atlas Land Surveying.
Is it 2 pages to it? Is it just that one?
I believe it's just that one.
Okay, applicants exhibit 2 is a site plan with septic design showing the existing 2-bedroom building and the proposed building. And it's by Atlas Surveying dated May 24. All right.
Okay.
So tell me why you have to move this new building so much further inland,
Away from the property.
away from the property line, but it's down, it's. I remember looking at this and wanted to make sure you're closer to the wetlands, is that right? No.
Not particularly closer to the wetlands, just slightly further away from the southerly
You're
property
further
line.
from the wall.
Yeah.
But, oh, I know what my question was. I'm looking at this in terms of.
Yeah.
Why can't you put the building in conformance?
There's a few reasons for the location that I've proposed, and primarily it's for the functionality of the modernized septic system I intend to install. When I began this process, I came here to the town hall to research paperwork on the property, and I was quickly informed by Wayne Pinkham that I would likely need to upgrade the septic for the existing main house, and that quickly became a major factor in what I intended to do. And as you can see, the topography and the grades have been worked extensively. This is a very historic property. So I'm limited in the space available to build an adequate septic. And I've worked very hard with my friend and colleague, Ken Cole, to design the appropriate septic system for the DEM requirements. And the grade has limited the suitable area for the septic, and the location I have proposed will provide me the adequate height, pitch for the appropriate septic.
Yep. Okay.
With that septic,
Mhm.
on the plans, it said it was a 6-bedroom.
Correct.
Is that 3 bedrooms for mom's house, a primary residence, and three
Three and three.
bedrooms for the 513.
That's correct.
Planning board question if it was a 4-bedroom or
Right.
3-bedroom.
My initial plans that I submitted had a bed downstairs, but I've since had that removed. That was just for size reference. I also had a closet, which I've removed. I've submitted new plans to make sure that it's clear that it's not intended to be a bedroom.
That's good. Start laughing, more people. What? The basement is just unfinished.
Correct. And I'd like to add maybe that, not as important, but in the terms of nostalgia, there's a historic stone foundation in that location that you can see. And that's part of the reason I incorporated the walkout foundation,
Mm-hmm.
so that I can use that historic stone as kind of like retaining the grade and keeping the historic nature of the land without disturbing it too much.
They have, favorable advisory from the planning board. And conservation here, and favorable advisory from the Conservation Commission. Okay, does anybody have any other questions? This is a public hearing. Does anybody have any questions, statements? Okay, I'll make a motion to close the public hearing and take it under advisement. All in favor? Thank you, Devlin.
Thank you all.
Hi. Hello. How are you?
Good evening.
Final hearing is Blue House Holding LLC, Eric and Jennifer Connolly, plot 17 lot 31, fire number 588 Beach Avenue, an application by Rob Sanders Architects for a special use permit under sections 307E, 406, and 703 for the construction of an addition to an existing single-family dwelling.
Good evening. Do we need to be sworn in?
Are you both architects?
Yeah, yes.
Architects need to get sworn in, right? They're not, just only, yes, please.
Robert Sanders. I do.
Andrew Almeida.
I do. So good evening. Andrew appeared before you in March for orientation. My name is Rob Sanders. I'm an architect from Wilton, Connecticut, and we've worked with the Connollys before in Wilton, and we're privileged to be here tonight to ask for the opportunity to work on their house here on Block Island.
Okay, great.
on
I'm
Beach
just
Ave.
going to interrupt you for 1 second, just a
Sure.
little housekeeping. Excuse me, I should have said.
No problem.
The documents that were sent on Monday, Monday, they fall within that, our 10 business day requirement. I didn't actually physically get them. So I don't know what I don't even know what I'm looking at. So before we waste anybody's time, I did get a sense of plans. I just didn't know if there was something that I couldn't
So-
open it on whatever, it just wasn't coming in. And Jen and I've been playing phone tag and
Sure. So we were looking at the agenda notice and saw that the written forms were not included in the public posting. All the documents that are there, the floor plans, Ken Cole's site plan from Atlas Land Surveying are all were all submitted for the record. The first submission goes back to March, and then for the July 10th planning meeting, all of those floor plans and elevations that are in your record, we have extra copies if you don't, were in the town's possession. So I believe everything was here and was posted properly.
Okay.
But I was making sure with Jen that the written forms, which were not included, whether that was a concerning issue with her or not. So.
Yeah. Right, that's what I didn't, that's what, I just wanted to make sure there wasn't anything in that
No, there was nothing.
sent out that we hadn't seen.
We do
had
have
time
an
to review.
exhibit which came in literally this afternoon, which is acknowledged from DEM that they have Ken's site plan in queue now on its way to review.
Okay, because that was part of the planning board's.
Correct.
stipulation.
And we can, Andrew, why don't you
Okay.
hand in one of those?
We'll get to that. Go.
Oh, okay. All right.
Do your.
There we go.
Is everybody okay?
All
with
right.
that?
If the house is kept,
They've already done the checklist, so right, so, yeah, okay.
okay, so if hopefully the house has been kept here and we'll make this as brief as we can. As you know, we are applying for a special use permit application. We were brought in by the Connollys, who are interested in connecting the two existing buildings on the site. You have an 1887 structure that sits on this 1.27. Thank you. Acre site. Why don't you go over there? We've done this before here. On 1.27 acre site, which is slightly under the zone requirement of 60,000 square feet. The existing house is 4 bedrooms. In 2005, the Connollys, actually, Jen's father and mother, built the freestanding garage structure, which has a bedroom space and sitting area above it. It is their goal to connect between the two and to take care of a challenging circulation within the existing house, which has an extremely steep single stairway to upstairs. So our mission was, in addition to connecting between the two, to provide safe stairways in between. There's 5 levels in between the two structures. So that's part of the challenge of what the circulation is doing. What we create is a grade level entry that's accessible. We create connections between the two parts of the house. We provide additional bathroom space because there's 1.5 baths in the house now, so we need more. And the volume comes partly from simply the distance between the two structures. Our concern, in addition to all of these things, as architects who are focused on historic design and responsive architecture, was to provide something in context between the two structures and volumetrically that respects the smaller structure and doesn't challenge the larger house next to it. So I think you'll see in your files plans and elevations of those, which we tried to be deferential to the building and maintain the characters of the two. The result is a design which complies with the floor area maximum of the site, slightly under the 4,000 square feet. Where we run into challenges are essentially on building volume. We have a non-habitable basement under the existing house, and I mean like this, which is counted as one of the square footages that pumps up our numbers. We have non-habitable attic space, which also pump up the numbers. And that's where we get into, as the report shows, the gross volume at 38% versus the 20% threshold. So, Andrew, if what we did prepare, and I believe is filed in the records that were on there, was a compilation of all of the various ways building square footage and cubic footage are regulated in your regulations. I think there's 5 separate ways that those tests are put forth. None of them exceed the maximum amount, but they all fall into, I should say, 3 out of 5 of them fall into the special use permit review process. And so that's why we're here to do that.
I'm just looking through the files.
So what, do you want to enter all these?
You want to start?
Well, let's do it.
Do you want me to play Sean?
Sure, you can do it.
You guys probably have a little bit more experience.
That's all right. Hit it.
What do you want to enter first?
Why don't we start with the plans and elevations? So those,
No,
under that, there should be,
these ones or the,
you know, let's see, you can start with Ken Starr's plan, perhaps. That's a good place to start. Excuse me, Ken Starr. That's a different man. Ken Cole, Ken Cole. That is, so you're coming up to Atlas Land Surveying,
So I have
site plan.
the site plan, which is,
If
this
it's-
is site and septic. Or site with showing.
Does it have our letterhead on? Show me.
It's Atlas.
That's Atlas Land
Site.
Surveyors. Yes,
Okay,
site,
so
septic.
Applicants exhibit 1 would be the site plan by Atlas Land Surveying showing the existing and proposed with septic, and it's dated.
It also has, and drainage infiltration on it.
There are 2. There's one with a smaller version than as requested by the previous planning board. There's one with a larger detail version.
Oh, I got you.
There you go.
Let's do the first, let's do the bigger one. Exhibit, it's dated January 24th. What? What? They're in the process. They're in the queue at DEM.
We have documentation of that. There you go.
Uh,
Yes. Those are ours.
Applicants exhibit 2 are the
Site plan,
site-
floor plans,
site
and
plan, Floor
elevations.
plans and elevations by Rob Sanders Architects, dated July 3rd, 24.
And those are the current.
Okay. After she marks that? You're doing great. You know, usually it's the person's first time I get to do this. Okay.
Then, the one in front of you, on the other side of the bottle.
This
Keep
one?
coming towards me. Drawings, pictures.
Oh, this on the picture.
There we go. Those are perspective views of the existing conditions and proposed conditions from cardinal points around the site. So there are several,
Exhibit
there's,
3.
that's correct.
I would have to say that this made, like, I could see it so much better because I'm
Good.
so visual, but thank you. That was
Good, I'm glad. And then I think that there should be a 4th document, which is a grid of the
Yes.
compilation of the numbers.
This one.
Correct. Well, exhibit 4.
Applicants 4. It's a square footage calculations chart.
And then while we're at it. And we have literally from DEM today, an acknowledgement of the review process underway on the OWTS.
Okay, I'm just gonna read this quickly. Applicants Exhibit 5 is a letter from the Rhode Island Department of Environmental Management. Addressing the application, it says, please be advised that your application for a freshwater wetlands permit has been received by the Rhode Island Department of Environmental Management. Your application has been forwarded to the Office of Water Resources for review. And that's
There we
5.
go.
Okay.
All right, I think we're exhibited, right? All right, so in general, again, our purpose to connect the two structures to provide and to meet all the levels, to provide an accessible arrangement for stairs. Also incorporated in the plan is a space for an elevator, because this is a multi-generational house. We've got the middle generation here tonight with us. There are younger ones and there are older ones. Jen's parents live next door, and that house is currently not accessible. So this is looking forward to the future on what our goals were as far as the functionality. And again, we did our best to be contextual in the architecture and respectful of what's there. Andrew, why don't you just walk through the different review areas and square footages?
Yeah, sure. So the building footprint, we're above the special use permit allowed of 2,000 square foot. We're proposing 2,288, a 11% increase. Living floor area, we're in compliance of under 4,000 square feet at 3,970. Gross area is up to 5,000 square foot. We're proposing 6,892, which is 30%, 38% above. Building volume is above 45,000 cubic feet. We're proposing 54,013, which is 20% above. We're in compliance with building plane, wall plane, all building heights, and all other dimensional requirements.
So we went to conservation in April and got a favorable review on that. We went to planning and we met with them in May, June, and July, and discussed primarily proximity to the wetlands and the wetland setback. The existing house, the existing septic dates to the 2005 addition. Surface runoff is not managed in any way. So as part of Ken Cole's design, we're replacing a relatively new septic system to meet the current code. We're not changing the bedroom count in all of this, but we're providing a new system. We are also doing complete management of all of our hard surface runoff in new underground systems. Planning's concern was that in our original application, which conservation approved, we had a setback from the wetlands edge of about 38.5 feet. In discussion with planning, excuse me, I meant conservation is okay. Planning was concerned that we were increasing the encroachment. The current corner of the house is at approximately 44 feet from the wetlands edge. So we did a redesign. We reduced our building volume and footprint to essentially create a continuous line at that 44 feet. And that's where we ended up with planning and their acceptance on July 10th. So we kind of came to that state of reasonableness, I guess is what we would call it, as far as the addition was concerned. So with that, we're in front of you now.
Okay, I have a question.
Sure.
In the notes, I'm just looking at the zoning plan review that the town uses to kind of go through everything.
Yep.
Before they come to us. Does a screen porch count, Karen, as living space?
Sometimes it does and sometimes
Yeah,
it doesn't. If I can,
Had that discussion.
Andrew can,
I
we actually have little maps to help
Yeah.
us. As
Yeah,
this is our
so
first
the
time on block.
town
you know.
Defines living floor area as the total floor area measured in square feet from the exterior limits thereof of that portion of a residential building which is used for habitation purposes, but excluding garage space, unfinished basements, and exterior spaces such as porches and decks.
In,
You can't use it year round.
that's right, in the different interpretations of this, there's one of every stripe. And, you know, this particular house is disadvantaged by non-habitable basement space being counted in the building.
Gross
um,
area,
Thank you, in the gross area.
which
on
I
this.
have that.
Same thing with
definition
the
as well.
attic. It's a 14 and 12 pitch on parts of it. So there's an aisle down the middle of the attic. But our floor area goes out and, you know, it's for storage.
You will.
So those things pump up the numbers on us. If you came back and said, okay, let's not count the parts of the attic that you can't walk in, and let's not count the basement, we would be down at a number that's closer on the gross area, back to the 11%, which floats around elsewhere in the numbers.
Yeah,
So
we'd be at 5,517 square feet, which is 11%.
You'd still be over the calculate.
We'd be over-
You'd
we'd be
still
into the-
trigger a special use permit.
we'd be in the special use zone, but not by so much. It inflates the other number. That's the one that catches in the eye. So.
Okay. Any questions? You guys have anything else you want to talk to us about?
I couldn't download the documents that were sent today.
That was
And they
it.
sure fell.
It was,
It was a belt and suspenders. I was trying to make sure that everything that needed to be in was in.
Okay.
So,
to be determined, yeah.
yep.
I have extra copies as well. You wanna hand them out?
Anybody have any questions? All right, this is a public hearing. Does anybody in the audience have any questions? Statements? Okay, I'll make the motion to close the public hearing. Oh, we do have, excuse me, we do have a, where is it? Conservation, favorable advisory from the Conservation Commission. And then the advisory, from the planning board. The stipulation, is favorable advisory, with the following conditions. The applicant must receive a Rhode Island DEM freshwater wetlands permit and OWTS permit and minimize outdoor lighting to be installed to ensure consistency with the town of Joram's dark sky compliant pictures. So
Not a problem.
That's
We agree.
yeah.
Obviously, we will need DEM
Right.
and
you have the DM
that's right.
process started. Good luck with that.
Yeah, yeah. So if there are any other
Anything?
questions?
Any other questions? No, I'll make a motion to close the public hearing. All in favor? Aye. Thank you very much.
Thank you very much.
Okay, we don't have minutes, right? Okay. Let's go to discussion. How's everybody feeling? I know. Sorry, everybody online about that. So this is like one of the things, like, if they'd gotten the 112 or right? Have they gotten through that process, we would be here. We can't send them back there. No, I can't bring tourists, but it's just frustrating because wouldn't be before us if everybody could just have a meeting of minds.
Approved or denied.
Right. It's just frustrating and
I have some questions about it. Can you answer?
Chris, yeah, sure.
Okay. To be clear, what became selected?
My suggestion is no. Here's the reason why. What the chair referenced, and it was right in the beginning of the hearing on this, was the reactive nature of how the ordinance gets enforced. A complaint comes in, an investigation is done, based on what's learned, a violation is issued, or it's not. It's not, and she was absolutely correct, it's not as if the zoning official or the building official drives around looking for violations. It's my understanding it's not the way it's done in New Shoreham. It's certainly not done in any other jurisdiction that I've represented. So regarding selective enforcement, I would say, no, it's not an issue. The fact that everyone in town uses tents for storage, commercial storage, potentially in violation of the code, I would say is an irrelevancy to whether or not what's before you is a violation or not. The argument that will ever, yeah,
What happens in other towns is no
it's not.
bearing.
But to say that even if everyone in town was doing it, to say that, well, why are you picking me out? It's not a valid defense to whether or not there's a violation.
Because they don't have notices of violations on the rolling.
Exactly. Otherwise, it would be a defense to, it would be a defense to every violation you ever issued. Well, there's someone else in town, you didn't violate them, so you can't violate me. So no, it's not a defense.
Go ahead.
We go by, I discount the argument that that the town solicitor could not be a designated official because we had testimony that the town manager appointed.
Yes, me too.
So we have to go with that. It is clear that everything on the property is being used to some extent, to a greater or less extent, for storage and commercial use. So whether it is a tent or a camper, it's being used. So I think we have no choice on this one, but
Storage.
to uphold the notice of violation.
I would agree with that, and I'd agree that because of it's temporary or mobile. I mean, they're tents are temporary. But that's what I'm saying, they're temporary. And the mobile, they could be moved, and mobile, I guess, yeah.
But for me, it's more the use they are put to as opposed to the device itself.
Right.
That is the intent of, that's the way I interpret that section.
I would agree with you. I feel it's just unfortunate because it's. Couldn't have avoided it.
Yes, yeah. And sorry, I think I'm not, you know, it obviously correctly. I don't know. Containers wasn't the only defense that is like enforcement. Yeah, that was in the defense, right?
No, they own the fact that they're for storage and, you know.
Tents. You know, I go back to the witness, I still think it's ambiguous, and people right back to where we were on the. You know, to me, it doesn't say it, make it clear, and then you can issue the violation. I think that's still.
But it does say, but not limited to.
I think that.
And you can take that, but think about
Well,
that. For Ed, what you said, that's chair.
Well, I think more appropriate is the argument, you like, yeah.
Oh, yeah, no. No, I think. No.
And then we also discussed like, there's tents everywhere, there's never been enforcement action in this regulation before. This is like the first time, you know. And honestly, like, I don't know what to think on the that issue. And I don't know what to think on the court order thing. I love to put the court order back to actually make the order. But I don't, you know.
Well,
So I need.
what's the motion number one?
Let's do, okay, so yeah, we have two different decisions here. So we have the first one, which is the containers,
Yeah.
storage.
Yeah.
Say storage containers. I will make a motion to uphold the town of New Shoreham's notice of violation.
I'll second it.
Any discussion?
Yes.
Yeah. Oh, it's just, well, yeah. This portion needs to be on record. I'll say it again, Sally. You ready? No, okay. Is there anything else, Chris, before I do it?
just to be clear, so this is going to be what we've been referring to as notice of violation 1.
I'll make a, I'm gonna read the description. VVO real estate.
She's not ready.
Okay, sorry. Oh, sorry, Sally. I thought you were. You got the fancy recorder out. Yes. I'll make a motion to uphold the Town of New Shorehams notice of violation for VVO Real Estate Holding, Lot 6, Lot 106 and 107, fire number 41 Water Street and fire number 89 Weldon's Way. For the notice of violation dated April 29th, 2024, issued by Karen L. Browning, Town Solicitor, regarding the zoning ordinance, Article 1, Section 111, General Prohibitions number 23. Is there anything else I should add to that?
No.
Okay.
Second.
Any discussion?
Yes,
Okay.
I just want to go on record to say that my vote will be because we don't have much leeway as a zoning board on this issue. And that I think the town council and the appellant did not do what they should have done, and that is come to a reasonable agreement on what would be best for the community.
I agree.
Yeah, I was just gonna say that, you know, we can't argue that there isn't a hardship for any of the businesses, Harborside, Oddfellows, or Island Moped, but 112 allows for that hardship and
To be relieved.
leniencies, and it's up for our board and our duty to review that zoning ordinance based on that, on this document here.
Right. Okay, motion made, seconded, all in favor?
Aye.
Great. Okay,
And who are the voting members?
I think we all are. We're down
Well,
no, 4, who voted? 5 votes, 4 vote.
Yeah, how about a roll call? How many, you normally have 5?
We normally have 6.
We only have 6.
7.
7? Who are we down right now?
7 is 2 alternates. I moved up to Judith.
You're Judith?
I'm Judith.
Oh, those are big shoes to fill.
Right?
So you normally have 6.
7.
7. Who are we missing?
5 members, 2 alternates. We
Well, when you say.
Oh, we haven't
when
had-
you say normal, we don't have them now.
We don't have them now.
No, not that they're not here. We don't have those.
We don't-
that many.
We are it. For
We
the
are-
zoning board right now.
We are the full zoning.
For all members with no alternates.
We have no alternates, right?
Technically, no.
Yes.
So you're an alternate? Yes. So you're not voting a seat?
Yes, you can vote.
No.
No.
Not unless you need
So
it.
there's 5 members. You're the 5 voting members, correct?
Mhm.
Yes. 5 can vote, so let's do it that way.
Sorry, Mark. Okay, sorry about that. I wasn't counting myself.
I don't suppose we could say something like delaying enforcement for a week to allow them to go back and do a 112.
No, because they can't go back, right?
Well,
They can go back.
They can absolutely go back if they wish. Remember, there's also a 20-day appeal period. from
Yeah.
Recording of your written decision. So there's a time.
decision.
There's a time.
We're not gonna have well, we just voted, so I guess it was like. So,
Yeah, which is,
yeah, all right.
but they can go back.
Are you taking a roll call vote now?
Yes.
Okay.
Just want to.
We don't have to write up a decision.
We don't have to,
No, we're upholding them.
Yeah,
so I take back my motion.
yeah. And then these are only notes, right?
If I, can I?
Yeah, again, yes, it's a written decision. Yes,
Okay.
you're making the decision, but there will be a written decision.
Oh, so I have to, we make the motion and then so I still,
Typically, we discuss and then the motion is made at the
The
meeting
following
where.
meeting.
the
Following.
final
the
meeting.
yeah, final, so we could,
That's the typical procedure that's followed.
Yes.
Right.
You're here tonight and you're ready to vote.
Yeah.
And I'm saying this, but special counsel listening, so you can correct me. You can vote tonight,
Correct.
so
but if it's not in writing, it's
That
not
could be issued.
enforced.
that could be,
That can be-
decision be issued
Yeah.
after. you vote.
Yes.
It doesn't need to be done now.
Does not need to be done.
Oh, by time.
Let's just go
The
on.
action that, you know, if
If this roll call vote ends as I think we'll know
Yeah.
this on the NOP one, the decision to uphold the NOP needs to be reduced to a written decision.
Correct.
Which gets recorded.
Correct.
Starts a 20-day appeal clock.
Right.
Yes.
Which
Yes.
does, which means that, this criminal is not.
Well, that's to speaking to the point, I just want to make sure that we do this the right way. I'm not,
Mr. Parks, you said, we all agree.
okay, so we can vote on it,
Yes.
then it has to be written
And record it.
and recorded.
Yes.
I have to sign it,
Yes.
and then the 20 days starts.
In the interim, they can go to whatever they want.
Do whatever they want. But that gets us to, that gets them.
Yeah.
That gets them some time. Okay, okay, okay. Motion made second, aye. Motion carries. All right, the second notice violation is the mobile, call them, they're not, that's like, that's all over the place for me.
Hold on, is NOV one just continuous?
Continuous intent.
Yeah, I can't go with.
You don't buy the tent?
I thought it was, sorry, I thought it was.
Okay, so you're gonna vote again,
Yeah.
against. Okay,
Included.
so we
All right,
have,
let's do this.
that's okay. No, it's okay. Instead of flying by, that's okay. I thought it was.
So
No, the 10th.
why don't we do this? It's just a suggestion, Madam Chair. Why don't you make a motion to rescind the vote you just took? If everyone agrees to do that, then you'll make a new motion and then take another vote. It looks like Mr. Filippi will be changing his vote. It's up to him. Why don't we do it that way? Is everyone in agreement that's acceptable? Yeah. Go ahead.
No, it's storage. Okay, so I'll make a motion to rescind.
The previous decision.
Right. Make a motion, okay. I'll make a motion to rescind the prior vote. Is that what it is?
Vote and decision, yes.
Voting decision. And I will make a motion. Okay, I'll make a motion to second, all in favor? Aye, great. I will make,
Mr. Filippi, that was an aye to rescind.
okay, aye. Where's this is for rescinding, aye?
No.
No, this is for the rescission. Okay. Poor Amanda's got like 40 pages of notes going on.
All right.
Okay. I will make a motion to uphold the decision, uphold the point, the notice of violation by the town of New Shoreham for VVO Real Estate Holding Inc., Plat 6, Lot 106 and 107, fire number 41 Water Street, and fire number 89 Weldon's Way. Appeal of a notice of violation dated April 29th, 2024, issued by Karen Browning, Town Solicitor, regarding zoning ordinance, Article 1, Section 111, General Prohibitions, number 23. I just add storage to that.
No, that's fine because it's
Okay.
included.
Motion made. Any discussion?
Roll call vote.
All in favor, aye. Okay,
On tense.
all right. Of course, that motion's made and carries, right? Okay. All right. Second up is the,
Sorry.
you okay over there?
A lot of rain.
All right. Is the town has asked us to amend the notice of,
No.
we're now on to the second, but we have a discussion. To amend the notice of violation. I'll let you. They want us to amend the notice of violation and add the prohibited use of the sale of automotive vehicles. I don't want to do that. I'm not into doing, yeah, with them issuing, I mean, yes, I know Karen said that they would just be back here, but that's not what's in front of us.
It's not what was posted, it's not on the agenda.
Yeah. How do people feel about that? I mean, about that, this notice of violation? Yeah, but what about the actual notice, which is that they're, so many papers. Oh, I asked for them. Trying to find the notice violation to read it so that we're clear. You have, is this the second?
There's one right underneath.
This is the, this is not, this is the. Yeah, that's very similar. Yes, could you read that, please? Yes, good. Okay, thank you. No, we're still in discussion.
You are hereby notified that you're in violation of the New Shoreham zoning ordinance. Article states general prohibitions. The following uses are prohibited in all except as noted zoning districts: car, moped, jet ski, and other motorized vehicle rental. The rental or lease of motorized bicycles, motorized tricycles, or motor scooters is defined as the use of motorized bicycles, motorized tricycles, or motor scooters where compensation in any form is received directly or indirectly by the person who is the registered owner, lessor, or sublessor of such vehicle from the person using, hiring, leasing, or renting such vehicle. The use of mopeds, including the parking, display, or rental along Water Street, is prohibited. You are hereby ordered to remove all mopeds from the property's Water Street. Do you want me to continue with it?
No, it's fine. That's
Okay.
good. Let's look at it.
So my question is where the compensation in any form, is it indirectly from the 107 to the 106? And that was my question in regards to the ownership.
But parking is not allowed. It says parking, so. On the. I don't feel really as strong. with this.
I mean, they spoke to the, being grandfathered by pre-existing the zoning ordinance. I mean, I used to work on in that building for years and years and years. I just remember Johnny Leone with a cigarette and flapping the things. In the 80s. I don't remember, I can't speak to whether or not there were mopeds there or not. And, I mean, they have been there for a long time. I would speak to it, they have been there for a long time, but I know it's. Maybe the affidavit. I don't have a problem with it either. I feel like they're not renting those mopeds. We know that because they're those weird little yellow weird thing with the side things on.
I don't have strong feelings about this, but I can't imagine that this has, the historic district approval or any of the other
Right.
things that.
It doesn't, but
Which
that
that's
doesn't.
not up,
the-
that's not
the-
up for us.
But the notice of violation is whether or not they are in violation to have those vehicles there. And they did speak to that they're somewhere in the briefs that about them being not rented, but there's some sales going there, and that is something that is not addressed in the notice of violation, so that's neither here nor there. I don't think that this notice of violation has the legs that the other one had. So I would support overturning the notice of violation. Especially now that there's with the other issue. Okay.
Motion after this or have a motion after that?
I don't know what the benefit about it. Well, it's still the same. I mean, it's still August. So someone else want to make a motion? No, I do it. I'll make it. I'll just do it. Does anybody else have any discussion or feelings about that?
My only question, I don't really have a problem with it, but since we are supposed to be adhering to the letter of the law.
Right.
And the letter of the law says that you can both have including parking, display, or rental along large streets prohibited. That's.
Parking and display?
It says parking, display, we know they aren't rental, but it does say parking. So. That's.
Everybody should have brought us snacks. I'm sorry, I started to make me. I'm just looking for the
That's very funny.
111A not in the.
Not prohibited, but you mentioned.
That's what they said. But. This is what.
the display.
As long as we're not just wanting, a little zoning of this in Iowa.
If it's a display, it's not a display of what they rent. So then is it? And then is it, is it just a parking space for something? Thoughts? Make a motion.
I'll make a motion to overturn the notice of violation dated May 14th, 2024, issued by Karen Browning, Town Solicitor, regarding zoning ordinance, Article 1, Section 111, General Prohibitions, number 19, on Plat 6, lots 106 and 107.
So just to clarify, when you're saying you're overturning, you're reversing it, right? You're not upholding it.
Second. Any discussion? I second it. Any discussion? All in favor? Aye.
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 Motion carried. Okay. I will make a motion to adjourn.
You want that? Question for the other one?
Right. Sorry about that.
Okay.
Oh, the other ones, okay, let me just look at the agenda.
We got Gibbons, Hart, Blue House.
We have no problem, nobody has a problem with it.
I don't have any problem with Gibbons, I don't have,
Nobody has a problem with Paul.
and I, with the DEM info on Goria, not Goria, but on Blue House. to have that stipulation that the DEM stipulation that the planning board added. The planning board worked really hard.
They may have an issue anyway.
Yeah, the planning board worked really, really hard on that decision. It was, I mean, he wasn't getting, they went through like tons of meetings on that, just because of the wetlands and the size of the house the Conleys cut the house back in
Yeah.
size.
But that's in DMs.
Right, and
Well,
now it's in DMs,
yeah.
we now, if I have no issue with, as long as we have that as part of the stipulation, again, the
Which they're
DM.
not gonna be
It's
able to
gonna be
move
anyway.
forward.
They, anyway,
Yeah.
regardless, so
Yeah.
just have it as
Yes.
part of, tighten up, I have no issue with it.
Okay, so.
With Gibbons and Hart though, can I just back up on that one?
Yeah,
I wouldn't mind seeing something that in both Gibbons and Hart, the principal residence must be someone that resides in the principal residence. It cannot be rented out.
for the owner.
For the owners of the property, they
I
must
don't-
reside in it.
You can't, it's a 513, you can't be your own 513.
Right.
That was when we had something, we had that come up and that was eye-opening, that you can't be your own.
You
513. You cannot be your own.
So I
513.
couldn't move out of my
Debbie, so for
residence.
Debbie to move into
Yes.
the new building
and rent her house.
and Devlin and Caroline move into the house, the original house. They would have to be the executive, they'd have to be the owners of the
So
trust
Debbie couldn't move out of her house
She-
and move in with Deb and Carolyn
and rent the
and
house out.
rent the house.
No, no.
But I still have a question. The new state ADU. rules-
But I don't think that's our
Why-
jurisdiction.
Yeah,
That's not a me question.
huh? That's kind of.
You may know this question for us.
Good night, everyone.
No.
Thank you.
Thank
Thank you.
very much.
So much, have fun.
So for the new 513s. Can the primary resident of the main principal house move out and move into the 513 and rent out their main residence?
This came back when we drafted that new ordinance.
Karen, I have another question.
I don't know.
The new ADU, the state, what the legislature did, it was just signed by the governor.
Yep, the one that just got signed, or
That's
the one
what-
that got signed?
Yeah.
Seconds ago?
No, just now,
Okay,
okay?
I'm just making sure.
How does that, what are we doing? How does that impact us? You're allowed by right. On a lot that's 20,000 square feet or more,
That's old,
huh?
that's.
No, it's just a pass.
Okay. That's a good discussion for another time.
Let's do
This
this.
is-
one.
Why don't, do you wanna email me, or I can email.
No, so there's special use permits, they require all that. We're done, we just have to farm them out and that's it, farm out the decisions. We have to finish this discussion, about the 513, but I
I'm
don't.
sorry to keep this.
No, it's okay.
Well,
It's okay, we just don't need Sally.
Got Nothing to do with tonight.
And it doesn't,
This
it's-
is hypothetical.
Well,
it could.
hold on, can we add, Karen, to a decision, to the stipulations that it only be for someone that's not the owner of the property, the 513? Does that have any bearing on zone? That's not a zoning, that's
Owner
a,
must maintain residence in the main.
No, 'cause that's a-
principal Structure.
Let me look at the order, because we talked about it, and it's just been a while.
because that's a civil thing, isn't
I know
it?
that there are a couple of provisions, to address that issue, and I just don't know the language about that. Going back to the. The issue on the 20,000 square feet,
Is
is that the question? I said.
it? No, it's 20,000 square feet, it's allowed by right.
Yes, that is. So there were changes to the ADU ordinance under state law in June of 2022.
No, this is.
I know what you're
Yeah.
saying. I'm just trying to find, because we dealt with that issue when we redid the ADU ordinance here in town. And I believe the town council and adopted something that was actually more permissive.
But it was before this.
And that's what, and the next thing I wrote, up, so the new ADU ordinance that you just adopted is.
Accessory dwelling unit.
The new ordinance address that. I have not looked at this,
Okay,
they're telling me this
But
was
this
just
is,
passed.
this supersedes.
So
Yeah.
that, the new, and that's not the only one, there was also other things that have been passed by the legislature this last session. Many of them come into effect in January, they're not in effect yet, but I have talked with your zoning official, your town manager, Weston Sampson, your consultant, and your current planner. Because you are, the town is shepherding through a ton of amendments to get current. This last round, including that one, will have to be addressed. It just hasn't been addressed yet because the town is still working to get the last 2 tiers of ordinances to the council. So how that is gonna change things, I don't know yet, but it's coming.
But that right now, though, is what stands. It doesn't have anything to do with what we vote here, but it
I don't
stands.
know if it stands, that one in effect as of January 2025?
Sure.
25.
No, 24.
So if that is in effect as of January 2025, whatever ADU ordinance are consistent with that. Anything that just passed this past session, that is still being worked on.
Correct, and that was just passed. But it doesn't have anything to do with voting on this.
No, you're just asking about.
So what, we cannot, I'm guessing we cannot put into our decisions that there be a non-owner resident in the 513.
In the principal.
In the, I mean, an owner, I'm sorry, owner,
Can we state that the
no.
owner must live in the principal residence?
Let me look at it to see. Your ordinance is either gonna say that or.
But, and can we, is that?
Could we insert that into a decision?
I'd have to look at that to see if there's anything in your ordinance. that-
So why don't we-
Well, why do you want to do that?
Yeah.
Well,
Just something I would like to see first.
Well, because there's abuses out here,
Yeah.
people.
You haven't done it with all the other ones, so.
okay, so how about this, because for
You need a gavel.
oh, where's John Spears' gavel? Yeah, he probably took it with him, he took it with him when he left. Okay, who wants to, we have, how many decisions do we have? Yeah,
Spoke with Chris then Gary.
yeah,
I think he's willing to draft those.
Okay.
And or in conjunction with staff. to work
Yeah.
together.
great, that's great. Fantastic. Love that.
And I will.
And then we,
question On both the legislative question and the question on.
Okay. we have 3 special use permits, they're all the same, you want Gibbons? Any, Hart, you want Hart? I can, you could do blue, no, you're gonna be no,
Go ahead. Yeah.
I'll do Blue House, cause I haven't written a decision in a while.
Thank you.
I was like, yeah, no, like. And then you can tell us to put it in or not at the end, in the decisions, and the stipulations, whether or not we can have the.
Yeah.
Just remind me to, Amanda, you have to remind me to write this decision. Like,
You can
not
also
weekly.
do the week.
Write your decision, sit down, just say, sit down and write it, because it will take me 5 minutes, like, it's not gonna take.
You can come visit me in the office.
Just write it.
And you can write it.
I'll love to have your food.
So, is this the first time you have gone up against each other?
Oh, no, 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 it's not a light. Oh, look.